funds. He emphasized that only cases with robust evidence would proceed to court, resisting external pressures for hasty prosecutions. Well, Dr. Yini also disclosed that oral committee, it has identified approximately $21.19 billion in potential recoverable funds from illicit transactions and undervalued state assets and their sales. Notable cases under investigation include the National Cathedral Project, the Power Distribution Service scandal, amongst others. In a specific instance, the Attorney General revealed that Juan Eduboahin, in collaboration with his wife, they allegedly embezzled up to 39 million cedis from a government agency. Well, Dr. Yini reiterated the government's commitment to transparency and accountability, stating that only cases with solid evidence would be pursued in court. Let's take a listen to what the Attorney General, Dr. Dominic Yini, some excerpts of the press briefing yesterday. And then we'll begin to dissect and sink our teeth into them. We have all the experts lined up for you. Remember that we'll be speaking with the Deputy Attorney General. We also have some anti-corruption experts, some anti-graft campaigners, I should say. Also on the bill this morning. We will recover our country. But first, here is Dr. Dominic Yini. He is the Attorney General of the Republic of Ghana.
The investigations also established that the proceeds from the suspects' activities were used to buy significant landed properties and other assets of considerable value both in Ghana and elsewhere. Now, ladies and gentlemen of the press, my fellow countrymen and women, I want to give you a sample of what we have discovered so far. We have tracked most of the assets. The properties that are in their names, their joint names, or sometimes in their, in their individual names, are as follows. We have number 2 Stream Park Drive, Mayfair Estates, LA, that is Accra. For that, they deposited, and we have the deposit slip as well as the receipt from the estate developer, $1 million United States of American dollars. Number 6, Edith Avenue, Mayfair Estates, Accra. Deposit 500,000 United States of America. That's American dollars. That's the initial deposit. All right. Then we have number 7, Edith Avenue, Mayfair, 200,000 United States of America. The property. Number 8, Edith Avenue, Mayfair Estates, Accra, 97,815 United States of American dollars was deposited for that property. But we are sure that other cash payments were made to complete the purchase and then the transfer of ownership. So we are tracing all those documents. Number 9, Edith Avenue, Mayfair Estate, 270,000 United States of American dollars deposited, initial deposit for the purchase. Number 10, Edith Avenue, Mayfair Estates, Accra, 150,000 United States of American dollars deposited. Now, he also owns a company known as Vertex Properties. Vertex Properties. And we've traced the proceeds of crime to Vertex Properties also. They have, Vertex Properties owns 27 houses located at Oyarifa. Each house costs, an estimated cost of 295,000 United States of American dollars. We also know that they have 2 properties in London that we are tracking, and I'm going to trigger the mutual legal assistance between the United Kingdom and Ghana for us to be able to lay hands on those properties. Now, we also know we've been following the bank transactions very closely, and we know that on February 11, 2020, they made a 16 million fixed deposit from the payment received from BNC Security. This was from the initial payment of 27,100,000 Ghana cedis. On April 3rd, 2020, Mr. Dubois alone withdrew 7,250,000 Ghana cedis, okay, in cash. He withdrew that in cash. This payment came out of the second transfer of the 21 million from BNC National Security to BNC, his private, company. On April 24th, 2020, 1.5 million cash withdrawal was made. On the same day, he made payments to a real estate company to the tune of 1,566,000. So you see the coincidence, okay, of the transactions that were taking place. Then February to September, out of the 49 million, which was transferred from BNC National Security to his private BNC, about 99% was withdrawn by him personally. And they were largely very large cash withdrawals. And we believe that those were the withdrawals that were made for him to make the deposit for the properties that are enumerated above. We are working diligently on several dossiers that will shock the conscience of the nation. If what suspect Edu Boahen and his wife has done is like a thriller in Manila, please brace yourself for a rumble in the jungle in the next few weeks. Thank you very much, ladies and gentlemen. Now, I also want to take this opportunity to tell everyone in public office who's listening to me that if you do what suspect Edu Boahen did, now I will come after you. All right? I will come after you. I'm not going to wait because I have the authority of Mr. President that if you engage in anything like what Mr. Edu Boahen has done, or any act of criminality, I will not wait. I will come after you. So this is a warning to everyone. Thank you, ladies and gentlemen.
This morning, let's get right into it. We have the Deputy Attorney General on the line with us. We also have a private legal practitioner also joining us on the phone lines this morning to delve into the matters and the reactions that they have sparked since the Attorney General and Minister for Justice, Dr. Dominic Ayene's press conference yesterday. First, to Dr. Shremsai, thank you so much for your time with us on the program. The Attorney General, your office has been in the news over the past couple of days in relation to the work you're doing to recover looted funds belonging to the state. The latest coming from the BOG's governor's residence search that the minority is still calling a raid and the subsequent discoveries that have happened. From where you sit as the Deputy Attorney General, could we have approached any of these in a much better way? For instance, the search at the BOG governor's residence.
Definitely, when you look at the issues of law enforcement and human rights, there's one thing that everybody would agree with, is that there can always be a better way to protect human rights. So I would not sit on national television and create an impression that whatever we are doing or what we will do is the best. So the very concept of human rights protection or law enforcement and the rule of law is it's something that we always strive to get better at. So from that perspective, yes, there can always be, a better way of doing things.
Let's backtrack a little bit to the search at the BOG governor's residence, where some of these incidents are also coming out from. There are concerns that the minority is still raising, for instance, that the search was not carried out properly, although there was a search warrant. Have these concerns come to your notice?
Of course, we have. These concerns have come to us as state institutions. We do not only deal with formal ways of concern, we also monitor what happens on the media, I mean, in the media, on social media, in Parliament. So we are definitely aware of the concerns that have been, raised.
Looking at the matters that have come out as a result of the search, for instance, the minority is saying that some amount of money, some 10,000 cedis, was taken. Some jewelry belonging to the wife of the governor was taken. When it comes to such processes, I mean, when a search warrant is obtained and the search is carried out when the court is aware of all of that, how should it properly be handled?
The minorities' complaints are not general complaints of how things were done. They were very specific. They made very specific allegations. They said jewelry was stolen. They said it was a raid. They said monies were stolen. I think at a point, they also said that food was stolen from the kitchen of the home. In fact, they called the national security operatives who carried out the search. They described them as hungry. So we are not here dealing with people with an allegation of general criticism of how things were done. We are dealing with specific allegations of criminality. In that regard, we have taken our time as a responsible state institution to, first of all, we took our time to, usually we are briefed before these exercises are done, because it is under our authority. We applied for the warrants, so we are briefed before it's done. We advise on how it should be done. We go to court to secure the warrant, and when the operation is done, we are immediately briefed. If the brief is not sufficient and we see that there are other areas that we need further briefing, we ask such briefing to be done. In this particular case, we were briefed twice, because after the first briefing, you remember last week I came out to say that it was done in accordance with warrant, and the manner in which it was done was in accordance with law. Yeah, so that is what we said. But when the specific allegations were made, we did another round of briefing to be sure that what we did, the first briefing was done, was not misleading. We spoke to our officials. We asked for evidence on what they did in terms of recording, so certain things were, so we took further briefing. We took further briefing from them, and yes, the briefing showed that the search was done and the basic rules of searching were complied with. So, for example, if you want to conduct a search, the standard procedure is that on your arrival at the premise, whoever is in charge of the premise, you have to introduce yourself and show your ID or identify yourself. If the person doesn't trust you, ask for further identification. You disclose you show your warrant. The person is entitled to read the warrant. After reading the warrant, you advise the person as to his right to counsel. If the person wishes, he gives you counsel of his choice. And that is done, then the person guides you throughout the search. And when you are done, you leave, and then that is procedure. And this particular procedure that I've outlined was followed. And we also have not been able to, the person whose home was searched has so far not raised any issues with us. So Dr. Addison has not raised any issues with national security, neither has he made any complaint to any state agency indicating that something untoward has happened.
Right.
So we the only time that we hear this is when the minority in parliament speak. And we are willing, as a state institution, to accept any complaints and investigate them and make sure that people's rights have been, violated in the process, have been given proper remedy in accordance with law. So that is where we are at this point.
Right. Let's now move to the case concerning Dubois and the press conference addressed by your boss, the Attorney General, yesterday. The lawyers representing Kwabena Dubois, who is the former Director General of the National Signals Bureau, and his wife, they are accusing your boss of violating their client's right by publicly declaring them guilty before trial. Is that what you've done?
Again, I think I understand the concern that the minority has raised. It is not a proper thing to use state agencies or public power to harass citizens. It is not a good thing to use public power to execute citizens. It is not a good thing to use public power to violate the rights of citizens. So, and when state power is used, especially criminal procedures are commenced against a person, the key thing is that in our society in Ghana, whenever a policeman arrests you, you're already condemned in the eyes of the public that you're a criminal. I can't deny that fact. So anytime you come in touch with any police situation, you are likely to be tagged as a criminal regardless of the outcome of the investigation. So we are very much aware of that. So you will notice that for yesterday we made this press conference. And from the press conference, you would notice that this investigation has been going on for some weeks. And no one knew anything about it. We kept it because we know that when people hear that we are pursuing someone with a criminal justice system, they already will judge the person. Okay, so we are very much aware of that. We are also aware that when you are conducting investigations at this stage and you bring matters concerning the investigation out, it may mar or derail or even disrupt the investigation and make it sometimes even fruitless. So we are aware of that. So if you watch, we've been quiet on this until Monday. Secondly, you would also notice that anytime you hear of anything about investigations, as far as this oral project is concerned, it is not coming from the Office of Attorney General or any of the law enforcement agencies. It's coming from the minority. So, for example, if you take Dr. Addison's search, the search was done, we completed, we left, no one knew anything until the minority leader went to the house and took a picture with Dr. Addison and displayed it and made all manner of allegations about that. So the point I'm trying to make is that the Attorney General and all the agencies under the Attorney General, and indeed the President himself, we are not interested in using the criminal justice system to malign people's character, to harass them, or to persecute them. We will use the criminal system, justice system, to do exactly what it's designed for, that is to investigate crimes and prosecute those that we find culpable. Now, the reason I'm saying all this is that I understand the concern that the minority is raising. But what the minority is not addressing or is not looking at is this other side, that those of us who use public power, we have the mandate of the people, and whatever power we are using belongs to the people. And when you are working for people, you need to keep them updated. We call it transparency. In a democracy, you cannot have a meaningful democracy if you are not transparent. The people, you cannot have a meaningful democracy if you are not accountable. The people who give us power, we have told them that we are going to investigate crimes. We told them that we are going to recover loot. And it will be completely, wrong for us to ignore all our promises and ignore the values of transparency, accountability, and proceed as if we have powers of our own. It is in that spirit of transparency and accountability that we thought it wise to let the people of this country know that the work you have asked us to do, we are doing it, and this is how it has gone so far. So it is a balancing act between the private interest of the persons who have been, who have been investigated, and the interest of the public to know. Something about democracy is that when you are not transparent and when you are not accountable, that is where propaganda can, prevail against you. So, for example, let's take this example. When we went to Dr. Addison's home, we took Dr. Addison's privacy into account by not coming public about anything that we did. And indeed, since January, our investigation, we have invited over 50 people. We have interrogated over 50 people. Many people have been arrested. We tried as much as possible to keep those things under wraps. So if I mention to you some of the people that that have been arrested, interrogated, and discharged, those people who are on bail, will be shocked. So we are very much aware of the private interest, but we also are aware of the public duty to be transparent. So we put these things together, and we decided that, look, what we have discovered so far on this particular case, we should make public. So that is in no way, a disregard for a person's private, privacy or interest. And it is no way trying people in public. In any case, the court itself is a public place, So the argument that when you announce to the public your findings of investigation and you inform them of what you want to do next, it is not fair if the minority is saying that amounts to trying people in the public opinion or court of public opinion. It is not fair and it is not right. And it is also not democratic to suggest that.
Deputy AG, we also have on the lines private legal practitioner Osman Al-Hassan. I'd like for you to hold on for me as I bring him into the conversation. Osman, thank you so much for joining us, Counsel. Are you also of the view that the comments by the Attorney General amounted to what people are describing as a public conviction while investigations were still ongoing?
Let me say good morning to the public and good morning to the Honorable Deputy Attorney General, my good friend. I don't think so, because as we all know, I agree in principle that public office, especially law enforcement bodies, should not use their offices to abuse the fundamental human rights of individuals. But it is always a dispute as to whether a particular conduct of a law enforcement officer actually, and in fact, abuses the fundamental human right of an accused person or a person against whom an offense is alleged illegally. Let's also agree, let me be quick to add, that the law has permitted the intrusion of public officers into our lives in manners that would otherwise be deemed as violation of our rights. And so, in a nutshell, let me say that there is a permitted violation of rights. And usually, this is done in comparison with a nobler cause. Something nobler can be the basis for which your individual rights may be violated, in quotes. And so, but coming back to what they are talking about, the actions of the Attorney General. Now, we have to understand that it is inevitable within our criminal jurisprudence that information or allegation about someone's wrongdoing or offense will come to the public domain at a point.
Right.
That is inevitable. Whether it is a charge in court, it becomes public. Whether it is an arrest, it becomes public. And let's an arrest, if you look at the procedure of an arrest in our criminal jurisprudence, you are the law enforcer is under a duty to touch you and to inform you of an allegation, of a charge. In fact, the Constitution says in a language that you understand. And you see, the law didn't say the law enforcer should whisper this into your ear. And the law didn't restrict this action to any seclusion from public. So you can be arrested in public, and you can be told your charge in public. You see, and so if it turns out that you are not guilty of that offense, you don't turn around and say that your rights have been abused. No, it is an inevitable part of the process of taking you through the criminal procedure. Now, so if, and I conclude on this, that at a point, information about you in respect of an allegation will be public. And for me, the time doesn't matter. Whether during arrest, whether in court, or in between the two, it really doesn't matter. Now, but as the Honorable Attorney General has said, you know, transparency and accountability is very key.
Right.
And that ties very well with the right to information that is in the Constitution for all of us. And you would see that in the advancement of that principle of right to information, the Special Prosecutor's Office has been specifically mandated to update the public on the same work that it is doing as the Attorney General. And that's by law. And so if the Attorney General, who is even the main person to do these things, and is now giving someone that authority to do it on his behalf, it said not to have that right to update the public and to be accountable to the public, then it will be a travesty of that principle. The right to the to update the public, or the duty to update the public on what is going on. And let's say that, you know, most of the time, I believe that what perception does is as dangerous as what reality does.
Right.
Public perception. Now, the Attorney General is wise to let us know that the public perception, which is always rife during these times, that any action of a law enforcer is deemed as a persecution of a political opponent. Now, this perception thrives in an environment of ignorance and opaqueness, non-transparency, because people don't have information about why someone is being arrested, about why someone is being investigated, about why someone is being treated in a particular way in the criminal proceedings. And so the Attorney General, and I will say that it is a bit novel, but it is positive that they have taken upon themselves to inform the public why they are taking any action against any person.
Right.
Now, I said somewhere that, you see, it's also very important that as part of the rules of natural justice, the accused person should also even have the information about which the Attorney General or law enforcement body is accusing him, or the facts that are being alleged against him.
Yeah, but
and I said, when it is public like this, when it's public like this, the accused person or the person against whom the allegations are made also have the benefit of the information. Now, what I will tell you is that even now, I have a client, okay, and he is arrested. Allegations have been made against him. I need the information. I need the allegation made against my client.
Yeah, but counsel, in situations like this,
can you give me some time to do this?
Sure.
I need the person who has made the allegation, and I was told to go to the regional command of Ghana Police with a letter before I will be given that information. Meanwhile, as a matter of course, I am entitled to it in order to be able to prepare the defense of my client. I have gone for that authorization, paid money for that information, but for 2 weeks, I still don't have that information. You see? And so for me, the action of the Attorney General, the steps they are taking to update the public, is in line with accountability, is in line with transparency, which are both positive in the advancement and development of democracy. Yes.
They are describing the posturing of the Attorney General that he is, prosecuting the matter in the court of public opinion even before it goes to court itself. But my question to you is, where do we draw the lines for probity and accountability and transparency, as well as not letting almost all the details in the matter out into the public domain? Now, if Adubuahin is your friend, if people know that Adubuahin is your friend, you're walking in town, people point fingers at you that, oh, this is the friend of Adubuahin, the man, people start calling him a thief, even though the matter has not gone to court for full-scale, investigation, conviction, and all of that. Where do we draw the line?
Would this be possible even without any information given by the Attorney General or not? It would, because the arrest will be public. If you are arrested, wouldn't people be pointing fingers? And that's why I said it is the criminal process. There are certain things within the criminal procedure that makes it inevitable for some of these things to happen. Because if you are arrested in public and you are charged in public, that has the same effect you are talking about, even if the Attorney General doesn't want the podium to give information about why the arrest and why the charge. That is possible, isn't it?
Yes.
And so if the Attorney General now comes to give us information about why the arrest is effected, why the investigation is being made, or why a search is being conducted in a person's premises, is it not positive? Does it not feed into our perception against the perception of persecution instead of prosecution? For me, I think it is in the right direction. But let me sound this, if it is possible for anyone to make a conclusion from the statements that the Attorney General made, that the Attorney General has unjustifiably or even justifiably made conclusions of guilt of the accused person before trial by a competent court of jurisdiction, I might side with the person. But to the extent that the Attorney General is giving the public pure information, findings of facts, that is forming the basis for the actions or the next steps of the Attorney General, for me, it is in accordance with constitutional principle of people's right to have information, and it is positive because it dispels the perception of persecution against public opponents, and it advances our democracy in a positive way.
Counsel, good news does not travel as far as bad news does. In the event that, what I'm saying is, good news does not travel as far as bad news does. In the event that Adubuahin is cleared after the case goes to court and all that has to happen legally happens and he's found not guilty, how then will the AG department, if you like, undo what has happened to him in the court of public opinion?
But is the AG or any law enforcer under a duty to undo the effect of the actions they have taken to bring you to court to answer charges? Again, are they expected to do the effect of public arrest and charge? No. That's why I'm saying that let's not mistake things that are necessary for any person to face a criminal charge in court to public prejudice about the guilt of an accused person. The two are different. You see, even if the public is not that legally educated to understand these distinctions, and for that matter, anytime an arrest is made, people have the perception that, okay, he is guilty of something. It is still permitted within the law for arrests and charges to be made, irrespective of those perceptions. And I don't think it is the duty of the Attorney General or any law enforcer to, after trial, in any event, even before the conviction, the arguments the Attorney General will make in court, the submissions it will make, the evidence it will adduce, and the charges, they are all allegations before conviction. So, if you say they should undo the effect by what? That they shouldn't have commenced the prosecutorial proceeding, or they should be convinced 100% that, oh, these things are going to secure conviction at all costs, and now become prophet, giving prophecies of what the judges will say in fact. And if they fail in that prophecy, then they are guilty of some wrongdoing. No, I don't think that is what we have chosen for ourselves as the laws. And for me, as long as this constitutes transparency, accountability, and public information that dispels negative perception of persecution of public political opponents, and update the public, assure them that the Attorney General is conducting its duty in accordance with what they have given it. It is right, in my opinion.
I see. Briefly from you, you are a lawyer. You've been following issues like this. What should be the trajectory of the travel of these cases?
Ask that question again.
What I'm asking for is that from where you sit as a legal practitioner, in the face of what we know right now, how should this case of Adubuahin travel?
No, you can't push me into that. You want me to make conclusions of the end of the case before it comes to an end?
No, counsel, no. That's not what we're asking. What we're asking for is, so right now we know what he's being accused of from the perspective of a legal practitioner. What happens in the prosecution of these cases?
Yes, prosecution happens after gathering of evidence. And after the Attorney General has convinced itself that these are the required evidence, they meet the standard of proof, and they meet the requirements of the evidence rules, they mount the prosecution. And during the prosecution, what happens is that the Attorney General charges the person. The person answers the charge in the docket. And an application for bail might be applied, granted or otherwise. A date is fixed for the trial, and the trial will continue until, and in the course of time, the Attorney General, now the rule is that, well, you file what we call the witness statement, and the witness statement will now be served on the accused person or his lawyer, so they know the evidence and all that that are being adduced against them in court, and they prepare their defense. And so at that point, and that's why I was saying, at that point, even you and I can make an application to the court and say we need it. If they think it is one of the pieces of information that should not be in public, then they will give us reasons and deny us. Or if otherwise, they give it to us. And that's so this is what is going to happen. And if the judge sees that the charges or the evidence and the facts are consistent with the charges, and they meet the required standard beyond reasonable doubt, then of course the accused person will be convicted and sentenced. Except that if at a point, we know our criminal jurisprudence also make provision for an accused person to admit guilt, and pending the sentencing, pending after conviction and pending sentence, they can do what we call plea bargaining, so that if the offense involves recovery of some property, and the accused person is willing to restore that property, it is up to the prosecution to now take it and say that we would do away with the sentencing.
Right.
And if the courts agree, then they are left out. And it is better, because usually we want our property back. You see? So this is what we can all envisage moving forward with. But I understand that the Attorney General also says there's a need. The investigation is still ongoing, which means there's a likelihood that evidence might come to add to this one, and even change the position of Attorney General and lawyers about what should happen to the accused person.
Counsel, you just spoke about plea bargaining, and I'm reading a comment from a listener here, and what he's saying is that if the AG begins to dangle the idea of a plea bargain, doesn't it suggest a certain improper approach to the prosecution, possibly coercive or politically motivated?
Oh, the question is whether what the Attorney General is saying is true or false. If it is true, what's wrong with it? If it is true that there is a process of plea bargaining, which means that the accused person is admitting that, okay, I have done it, but I'm willing to restore whatever you think I have taken. What is wrong with that? Is it not good assurance to the public that indeed the Attorney General is working on its mandate? Yes, I think that's how I see it.